Buckle up, because what starts as a routine landlord-tenant hearing spirals into one of the most emotionally charged eviction showdowns we've seen in a while. The case IPF 16 LLC versus Kiara Fleming. The issue: over $4,200 in unpaid rent. Conflicting claims about rental assistance. Hay and a defendant teetering on the edge of contempt. Kiara says she mailed in the required rental assistance forms. The court says it never arrived. Meanwhile, tensions explode when the defendant interrupts, the judge leading to an immediate removal from the courtroom. But it doesn't end there. When the case resumes, the court learns more about Fleming's financial struggles, a last-minute payment offer, and the exact limits of help from agencies like SOS and HAWK. Judge Simpson navigates the emotional storm with firm control, but not without expressing clear frustration. Will a last-minute $900 payment be enough to sway the court? Or does the $4,298.39 judgment seal Fleming's fate? Let's break it all down.
Am I understood?
Yes.
You know what? I'm going to pass the matter. You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Keep back talking.
And here's where it all boils over. Judge Simpson has already warned Ms. Fleming not to interrupt, but as the tension escalates, so does her defiance. It's a risky move in any courtroom, but especially here. The moment she talks over the judge again, the session screeches to a halt. The judge sends her out to check her attitude, making it clear this courtroom isn't a debate stage. What would you do in this moment? Stay quiet and hope for leniency, or stand your ground and risk the judge's wrath? This isn't just about unpaid rent anymore. It's about courtroom conduct and the consequences of not following protocol. Let's see what happens when she returns.
Nakia Turner, parties have returned. Mr. Pantera, you were in the middle of your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her, and it's my understanding that the rapid rehousing ends at the end of July. So in August, she's going to be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think it's a tribal issue of fact. We would ask the court for a judgment.
All right, ma'am, what did you wish to say?
Anyway, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Ms. Terry through SOS that I ended up losing my job, and I wasn't able to pay nothing at the moment. And I'm just now getting a job, and I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car, so anytime I go anywhere, I have to get on a bus with my children. So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SER to this courtroom with the judge with your name on it, Cedric Simpson. But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help so I can get help with my rent. And I'm able to pay altogether $900 today, but that's all I can afford.
Well, if we get to August 1st, then August rent is going to kick in, which means you're not going to be...
No, August rent is paid by her, by SOS.
I'm going to let you finish because I'm not going to be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance. And I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Your Honor, I'm willing to extend the judgment, normally be the 28th. If we were to extend the judgment to August 4th.
There's no tribal issue for this court in regard to this case. I'll grant a judgment court possession with the redemption amount of the $4,298.39 with a writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean?
I just issued a judgment, the 429839.
Now, here's the legal pivot point. Judge Simpson just granted a judgment of possession, meaning the landlord is officially entitled to take the unit back if payment isn't made. But there's a twist. He's extended the redemption deadline to August 4th. That gives Fleming just over 2 weeks to pay the entire $4,298.39 if she does. She gets to stay. If not, eviction moves forward. This is a classic example of how courts balance due process with practical mercy. The court isn't ignoring her efforts, but the numbers, deadlines, and documents matter more than promises or assumptions. If you were in the judge's shoes, would you have done the same?
So I won't have to worry about August.
Maybe you're not hearing me.
I'm hearing what you said.
The judgment, I'm not dealing with August.
I know that. I'm just let you know for sure that's going to be paid. That's all. But thank you. Have a nice one. Thank you. Jesus. People with rooms.
Won't stop.
No, doesn't work.
Don't understand the assignment.
This case is a powerful reminder that courtroom decorum and documented evidence carry serious weight. While Kiara Fleming returned with a more respectful tone and a partial payment offer, the judge made it clear intentions are not enough. The judgment stands at $4,298.39, due before August 4th. If paid, she stays. If not, eviction is imminent. The court took her job loss and new employment into account, but ultimately prioritized the facts, the timeline, and the law. What do you think? Was this a fair ruling, or could more leniency have helped? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns every week. Until next time, stay informed, stay sharp, and we'll see you in court.